Excellent. So an application for copyright registration can be filed by the author or the owner of an exclusive right of work, the owner of all exclusive rights, or an agent on behalf of the author or owner. And the application basically contains three essential elements. It contains, first and foremost, the non-refundable filing fee that you gotta pay in order for them to do anything with it, right? You also need the application, a completed application form, and then you need a non-returnable deposit, which is a copy of the original work that they're going to hold as an example of your work. And that is deposited into the Copyright Office. What do you get in return? You get a certificate of registration, which then creates a public record of key facts relating to the authorship or ownership of the work. It includes the title of the work. It includes also the name of the person who has the rights to the work and the address, so that people who may want to use it, they know how to get in contact with you. And then they tell you when that right was created. So you can submit that application either through the mail, or you just go to the copyright website, copyright.gov, take the application, and then start that process. And so once your application is approved, you have that copyright from the date of that you had all your information completely submitted. And it actually goes down to the date of filing, okay? Works for hire. So we're going to go into works for hire. What do we mean by that? It's one of the exceptions to the general rule of claiming a copyright. We said from the beginning, copyright is the right that belongs to the original owner or the author, right? Well, here's one of the exceptions. The author is not an individual who created the work. Instead, it's the party who hired the individual, and they are the ones that are considered the author or the copyright owner. So we changed the scenario a bit. We hire the members to create the website, and we pay them for their work. And so that starts out with, then who owns the work? Who owns the work?
The church does.
Exactly. The church owns the work because they are the one who hired it, and the work is considered a work for hire. That is a legal term. So basically, what happens is you can do a work for hire through an employment, and you can do it by contracting with an individual. So what are we talking about for employment? To the extent that that person produces that work within the scope of their employment, then that work belongs to the employer. It is a work for hire. Independent. You have a question?
Does it include all of the working papers, or does it include just the final product?
If you create, the question that she asked is it, go ahead.
Does it include your working papers, or does it include the final product?
It depends. But the real questioning that they're going to look at is, when the work was created by an employee, was it part of that employee's regular duties? Or when it's so that's what they're looking at. Is it within the scope of your employment? Was that what you were being paid to do and produce? And if it is, then the argument can be that it is a work for hire. So, if it's a contractor, one of the things that we say that you should do Especially when you're dealing with a finished work, do a contract. And let the contract say, this is a work for hire. We are hiring you to do this, and we are making it clear that when it's finished and you've been paid, we own it. All right? That avoids tons of litigation in the future. Question? That's you, second row. Oh, okay.
What if it's not what you're getting paid for, but you're doing it on company time?
That's a great question. Because then the question is it still belong to the company if you did it on company time, on the company's computer, using the company's equipment? You know, you might put yourself in a position where they can argue, it's mine.
Yep.
And you got paid while you were creating the work, right? So, okay.
Somebody's asking a question.
One second for the mic. Just be mindful that we are recording the session, so we have to make sure we can hear your questions.
Just for a clarification, let's just go back to when you talk about volunteering for the church. You're doing a website for the church, right? And you've done the website for the church, and you decide to leave. Or, let's see, does that church own that website? You volunteer to do that website.
Yep.
You decide to leave. Does the church own that website? And so when you leave, right, you leave everything, turn everything over to the church because it belongs to the church. I don't know.
Right. What we will say is it all goes down to what was the intent of the parties, right? And it only really comes up if there's a dispute. If you voluntarily decide, I did this for the church, there's no issue, right? The issue comes if you say, oh, it's mine now, and I don't want you to use it anymore. Then the issue is, well, did it continue belonging to you, or was it the intent of the parties to transfer it over? And if you don't have a clear way of finding that answer, then you can possibly go to mediation, or then you may have to go to litigation, and it's an issue of fact, which means evidence, attorneys, and arguments to try to see if we can reach an agreement or you decide to voluntarily walk away from it. So our issue is you opened up a dispute because we weren't clear up front as to the intent of the parties.
I think one way to handle it would be in the very beginning of the agreement, that there should be some document drawn up, maybe with the help of an attorney, saying that the administrative rights to the content management system, so forth and so on, DNS, all that ownership would be transferred to the church. That should be done, I think, at the beginning, so that when this situation comes up and they say, oh, I'm leaving, I'm not involved anymore, the church has rights to the site. Because what happens with churches, the church website or any website, you have to have passwords to get onto the content manager. So if that person takes those credentials with him or her, you can control the website. So if you make that known in the beginning, okay, you're volunteering, we appreciate that, but there needs to be a statement that says, when you leave this church or for any reason you are no longer involved with the site, that A, we own it, and B, we have access to it. And that person has to sign off on it, because it's risky if you just say, and that happens with sound equipment.
Yes.
I've heard a number of churches say, yeah, John's a great sound guy, and he bought all this sound equipment, and he put it in, and the church is great, Now he's angry with the pastor, he packs up all his stuff and he leaves. We've had churches where pastors have come and opened the church for service and half the audio equipment's gone. Because they got angry and they took their stuff. So there are these areas that really need to be, dealt with at the beginning. And if you have an attorney in your church, or you can get an attorney, to give you some guidance on that, so you can avoid that. I have one question for you.
Sure.
This was a scenario that came up years ago, back in the day when we had cassettes. Remember that? How many people remember cassettes? Okay. There was a gentleman who called from his church, called my office, and he said, "We've got a problem." I said, "What's the problem?" "We're making cassettes of the pastor's sermon, and we're selling them, and the pastor is demanding the profits from the sales because he said it is his sermon. However," I said to them, "Is he preaching the sermon at his assigned church?" "Yes." Now the question is, who owns the recording? Because he is paid by the Seventh-day Adventist Church to preach at his church. Now, we're not talking about a week of prayer across town or somewhere. We're talking about his church, preaching to his congregation. It's being recorded and sold, just a sermon. We're not talking about any music, just a sermon. And the pastor is saying, "Well, if you're selling these for $5, I want $2. Because it's quote unquote intellectual property."
Right.
How do you deal with that?
Great question. The issue is this. The employer really should establish the policy. The employer should establish what are the conditions of employment. And intellectual property of a pastor is actually a key issue that too many conferences have not dealt with. Because there are tons of pastors who believe every sermon that I write belongs to me. It is my work product, and I own it and I control it. You can argue based on the law that it is within the scope of his employment or her employment, and so what she creates or he creates is part of their job function, and that's what they get paid to do. Well, let me ask you this. What if they're a pastor that has been pastoring for years, and they have a volume of sermons that they've already created before they entered into this particular conference? Can the conference even argue that this is a work for hire? Because the work was already completed and they're just presenting it. So these are issues that are not answered, and the issue starts really with expectation. The conference as the employer may have an expectation, the church may have an expectation, and the pastor may have a completely different expectation. And if we don't clear it up, you can't have a dispute where each side may have a valid claim. I know that doesn't give you a right line answer, but the question is, it is important to actually establish the intentions and the understandings of each of the parties up front.
Right, that's what I get from what you're saying. It really does boil down to the conference establishing a policy that when a pastor is hired to work in a particular area, that somehow it is in, they're signing on, understanding that if you preach sermons in your church and it's recorded, it may not be that exact wording, but you understand that that recording belongs to that church, or not.
Or not, right.
But it has to be in writing that both parties sign off.
Right. So, benefits, let me talk about the benefits of a work for hire. Authors and heirs can terminate a transfer after 35 years under certain circumstances. So this is, we're talking about where there is work for hire that is assigned to the owner, or you can actually terminate it after a certain amount of time. Written notice is required. You have to actually record the fact that you terminated that right, and a fee may be required to actually terminate that right. So it is actually possible. So the effective date of that termination is really based on when the notice was given upon the owner or the person of interest, and then the fact that it was recorded. And if a fee is required, that's how you effectuate the termination of that transfer. So, we talked about the contract, and that's essentially how you do it. What is a contract in essence? All a contract is an agreement between parties that's enforceable in court. Because there are tons of different agreements or discussions that people can have, and it's not even worth anything. What makes a contract worth a little more is if you have all the elements in place, a contract can be enforceable in court. And most attorneys will tell you a contract is only worth the paper it's written on, which means if you try to do a verbal contract, you are opening yourself up to a whole lot of hurt. We're not saying you can't win, but it is so much harder to try to prove a verbal contract when there is a disagreement, which is why we say take a little time to put something put it in writing. So when we're establishing whether it's a work for hire, we look at the words of a contract. This is why we tell you do the agreement. Does the website design qualify as a work for hire? Was that the intent of the parties? If you do a contract, if you do an agreement, it tells you what the parties intended. What was included in the terms of the independent contractor agreement? Maybe the person who designs it says, look, this is my work product, I want to continue to own it because I may want to use that same design somewhere else. So maybe the intent is, I will continue to own it, but I will give the church a perpetual license to use it for as long as they want to use it. So there are ways that you can devise your intent, which means that the person continues to own it, they can use it somewhere else, but it doesn't affect the church's ability to use that contract, okay? So next question. The pastor is writing a book on the history of the local town. He wants to include some photos that he took for the local church in his book that he is writing. Can he? Recognize, he wants to include some photos that he took for the local church in his book that he is writing. Can he do it?
No.
Yeah. All right, how many people think he can do it? Raise your hands. Don't be shy. If you think he can do it, raise your hand. How many people say he can't do it? Raise your hands. All right? It all depends. Again, right? What was the intent and who owns those photos? And if he doesn't own those photos, the only way that he can actually use those photos is that he has to get permission from the person who actually owns the photographs. So he may have taken the picture, but he may not actually own those photos. So some months later, local church receives a cease and desist email from a stock photo company stating that some of the images on that great website were used without permission. What should that church do? Huh? How many people say take down those pictures? How many people say leave them up? Because there are.
They should cry.
If they can verify that they paid for them,
No, but you just
then
stop,
they
you said
verify.
stop. If it's stop.
But if they can't, I would say they have to take them down.
Right. So I would say, yeah, you start with taking them down. and then you can verify whether you have ownership. Why do we want to take them down first? Well, let me tell you why.
They may be able to charge you for how many times somebody.
Exactly. There's something called infringement. And infringement is based on how long the infringement is taking place. So, to the extent that you are infringing that copyright, for as long as you keep it up, that just continues to toll the time under which they can claim damages against you. And let me tell you, they have created genius devices on the internet, for example. They have bots whose job is just to go on the internet and look for content. And then once they find the content that is within their library, they ping it, and then what's happening next is they're going to determine whether or not that individual has permission to use it. And if they don't, they can try to generate money for infringing on that right. So, what is infringement? The use of whole or part or the heart of a copyrighted material without permission. An adaptation of a copyrighted material, i.e., you take Obama's poster that was in the red and the blue, and then you impose your picture, or you take his picture and then you reverse the red and the blue on the other side. That doesn't make it original. It's an adaptation of the original, you know. Or you say Hamilton by white folks. That doesn't make it new, right? It's still an adaptation of the original work. So, or you have a license and you use the product or the image or the copyrighted material outside of the scope of what you got the license for. All of that is an infringement. So anytime you go beyond or you don't even have permission, you have infringed on that copyright. Okay? So, what is a good example? So penalties for infringement. U.S. copyright penalties include actual damages, any profits of the infringer, or statutory damages. And statutory damages can range from $750 to no more than $30,000 for each work. Willful infringement up to $150,000. Prison terms can be given for willful violation. So there's some serious penalties that are involved with infringement of a copyright. Here is a good object lesson for infringement and why you have to be careful. If you bought this forever stamp between 2011 through 2014, what do you think this is, what would you say this is a forever stamp picture of? Statue of Liberty, right? Makes sense. Actually, that picture of the forever stamp was a replica, a picture of the replica of the Statue of Liberty that is found at the New York Hotel in Las Vegas. Anyone been to Vegas? You've seen the New York Hotel? They have like the fake Statue of Liberty and a few skyscrapers. This was actually a picture of the New York Hotel, not of the Statue of Liberty. So, the post office licensed the photo of Davison's statue. So this work was created by Robert Davison. So they got the license from Getty Services for $1,500, initially believing that it was the picture of the original Statue of Liberty. The license only covered the rights to Getty's photograph of the statue, but not of the statue itself. So, what was the result? They released this stamp in December of 2010. It took 4 months before anyone even noticed, that anyone even noticed that this was the wrong picture. So it then went to litigation. At the end of the day, what they resulted was this was an infringement. What did the judge decide? I think the judge decided determine how many of these stamps were purchased but never used. When they determined that number, I think that number was about $70 million worth of stamps were purchased but never used. And they gave the owner a percentage, and I think that cost ended up being a little over $3 million. So they thought they bought the rights for $1,500, but they didn't buy the rights, but they were, one, buying the wrong thing, and two, what they bought the right to in the license was the right to use the picture, not the right to use the likeness of the statue that is in New York, outside of that intention. And because they made that careless mistake, it cost, for an infringement cost, about $3 million. So that's an extreme case.
Well, yeah, I just wanted to clarify a little bit with the stamp.
So they did buy the right to use the picture that was in the hotel in Las Vegas.
No, they thought they were buying, this is what they thought they were buying. They thought they were buying a picture of the Statue of Liberty.
Okay.
But what they were actually buying was a picture of the replica of the statue. The statue itself is a copyright.
But the picture that they're using on the stamp is the picture from the hotel.
Right.
Which
Is owned by Robert Davison. That work of that statue is owned by Robert Davison. So this is why we say you have to be careful and intentional about what you're doing. So careless as the post office was to just get the stock photo, we think this is the Statue of Liberty, we're good to go, ended up costing them tons of time in litigation and $3 million worth of funds that they were not expecting to part with. And I bet they probably, if they had first of all, they weren't even intending to use the replica of the actual of the statue that was in Las Vegas. They really wanted a picture of the Statue of Liberty.
Did that guy get the okay from the Statue of Liberty?
Statue of Liberty is owned by the government.
So he didn't have to,
Right. So the issue was that statue itself copyrighted? And it was. And that's why you had to purchase, even for the picture of it, you had to get permission. But if you're getting but that is for the intended purpose. It's not to use it outside of the license. Just remember when I said, make sure whatever you're using it for, the license that you get is for the intended purpose. They used it outside of its intended purpose, and it cost them substantial amount of money in litigation. All right, here's another example. Anyone know what that is?
Okay, it's the bean.
The bean, right? They call it the bean in Chicago. It's actually called the Cloud Gate, but I call it the bean too, right? The bean. So the British sculptor, his name is Anish Kapoor. And there is an illustration. There's actually a recent litigation that's happening because that image was used in a commercial by the NRA that had it in its background. And the person who owned the sculpture actually filed a copyright infringement lawsuit, and it's still pending as of 2017. And the question was whether or not they could use whether or not the NRA infringed on his image because they had it in the background. It is pending. The question is really going to be, Was it the focus of the commercial? How long it was in there? Was it just an incidental use? Or was it used more than just incidentally? And those are all questions of fact that has to be litigated to determine whether or not there was an infringement. So the moral of the story is you have to be very, very careful about what you do, even when you're filming things, to make sure that you're not putting yourself in a situation where there can be an infringement. I mean, have you heard so many times that, for example, our President 45, he would constantly, everybody has a theme song, right? Obama had his, what was his theme song? Y'all remember what Obama's theme song was? No? It was, how y'all forgot already? 4 years that much? Signed, sealed, delivered by Stevie Wonder. And he played it at every rally, at every campaign stop. And he continued to use it. Anybody remember what was Trump's? He had, right, but here's what happened. Every time he used one, people who had the copyright would be like, didn't give you permission to use that. You can't use it. All right? Local church takes down potentially infringing material but still wants images on its website. What are some of the alternatives that it can do to replace those images? Huh? Use real people? What? Right, you can get permission. What else can you do if you're in a hurry?
Well, if you have a license with like a Shutterstock or other group, and also providing, understand, even if you have purchased licensed images from a Shutterstock or other company, they're very specific as to how you can use that image.
Right.
We recently worked on a project with an AV that involved Amazon and some images of a product that they had. Well, we thought, since we're doing this for Amazon, and we have an agreement that we can use their images. Not so. So we went to Shutterstock, and they happened to have images and logos of Amazon, which we could use because we had a license. However, even that had a stipulation. You can use the Amazon logo, you can use this Amazon image for this purpose only.
Right.
So if it was for a movie or video, maybe they say you can't use it there, but you can use it for print media. So, even when you buy a license, it comes with stipulation.
Exactly. Or you can go and have somebody take pictures with the intention
Work for hire.
of giving you the right to use those pictures. Exactly. So, how to avoid copyright infringement. You want to make sure before you start using it to determine whether the work you want is copyrighted or it's part of the public domain. But if it is copyrighted, you've got to get permission. It is so much cheaper to buy a license up front to use it for the purpose than to pay infringement costs. Infringement costs are substantially more expensive than getting the license. So, what are works that don't require permission? Original material, material that is in the public domain, and use that qualifies as fair use or fair dealing. Original material is, I took those pictures. I created the sculpture. So it is my original, or I hired somebody to do it for me, and I have documentation that it belongs to me. Material that's in public domain, things that have been there over a certain time period. After a while, it is no longer copyright protected. It's considered part of the public domain, which means you can use it without infringing on the copyright. And then there is these qualified uses that we call fair use or fair dealing. What are we talking about? It's an exception to the protection. The fair use of a copyrighted work for the purposes of, remember this, if you're using it for the purposes of criticism, comment, news reporting, Teaching, including multiple copies for classroom. Scholarship or research is not an infringement of copyright. In determining whether the use made of a work in any particular case is fair use, the factors to be considered shall include the purpose and character of the use, including whether such as a commercial nature or a nonprofit educational purposes, the nature of the copyrighted work itself, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, how much of it you're using, the effect of the use upon the potential market for or value of the copyrighted work. So again, it all depends, but there are some factors that guide whether or not your use is in fair use. So for example, I'm doing a presentation about copyright and what is copyrightable and what isn't, and then I have certain examples of what is copyrighted material in my presentation. Displaying that for the purposes of education is not a copyright violation. But taking a copyrighted material and putting it on on a t-shirt and then selling it for $10, or fundraiser for my student association, so I let you watch a movie for $3, that's a copyright violation.
All right. What about selling your presentation?
That you did not, that includes material that I don't own, probably not a good idea because that's outside of the use. So, or even publicly putting it out there. So oftentimes you'll see if you're gonna post something online or something like that, like our material or a deck presentation, we'll do the deck presentation that probably doesn't have a bunch of the copyrighted materials in it. All right? So these are factors. And so I said, don't really put all your chips into fair use because it's not an open and shut. There are various factors that come into play. But the more you use it for commercial side, or you're getting a profit out of it, or things like that, you're gonna be outside of the fair use, okay? So, these are the actual things that we've seen church members do. Emmy Award for Music and AV Department, celebrity host, special guests, performers, live band, and more. That's all great, right? But Emmy Awards, and they have the Emmys. Is Emmys copyrighted? Yes, it is. Is that a copyright infringement? Yes, it is. Yes, it is. If they didn't get permission to use it. Is this fair use? I actually put the name so the person's on blast. This isn't our conference, but next time it might be. Women's Ministries, The Circle of Life, 5 p.m., blah, 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 but they have 4 pictures, right, of well-known women. Is that a copyright infringement? I don't know about that. Well, here's the thing. One, they are a celebrity, right? So celebrities don't have as much protection over the use of their image, but you're using photographs, and the question is, were any of these photographs in the public domain? Or did you just download photos that may actually be copyrighted, and you're using them outside of the intention of a license? Maybe you don't even have a license, or you're using it outside of its intended license that you do that. All right? So these are the kind of things that you should be helping your church and your conference avoid infringement costs. So how do you avoid getting yourself into trouble? One, Creative Commons licenses. What are we talking about? Free licenses that are open to the public. The organization has released several copyright licenses known as Creative Commons licenses, which means it's free of charge to the public. which means you have the right to use it. However, there's always a but. The original creators may still reserve or waive certain rights to use their images or their protected work. So even though it's a common creative license, you got to make sure you do your research to understand whether they reserved any work. So they could say, hey, as long as a nonprofit is doing it for a program that is not generating any kind of income or revenue, you're free to use it. But the moment you think you're going to generate revenue or it's made to produce some kind of income, that permission may not extend to the use of that license.
Just a question. So if someone, that's for the examples of programs that you have, there's no, let's say, money involved, but yet they might have violated someone's copyright.
So if a church created similar, like all those things, they weren't involving money. They weren't saying, you know, pay this amount.
Yes.
You know, so money wasn't involved. So if a church, so when a church finds out that they're in violation, like a cease and desist, the message would be, we see a problem, we're telling you about it. It's not going to be like, we see a problem, here's the charges of the infringement. Like, can you talk about that element?
Sure.
Because if you just go online and surf, Lord have mercy on
You're
the
gonna see all the
infringements.
stuff that's.
Yeah, so I'm just curious about.
I'm gonna tell you, when I talked up with you about bots, they have literally created bots whose job is to go online and look for their clients' protected work.
Amen.
And when they find that protected work, it isn't just to tell you to cease and desist. It's to generate money for the owner. So they say, you have infringed on my, trust me, my colleague does this all day where she receives infringement notices of churches who have taken protected work and used it, or pastors who have created PowerPoints or presented sermons and they don't have permission to use protected works, and they are displaying, publishing, distributing it. They find it, they categorize it, and they send an infringement settlement bill, meaning this is what I'm entitled to. I'm gonna charge you $1,500. I'm gonna charge you $25. I'm gonna charge you $5,000. And generally, we will negotiate, we will pay it, and then we will bill the conference where that came from. So we have to be mindful that these things cost. The government protects people who have protected their work. So people are sophisticated enough to figure out how do we find people who infringe on our rights, and then we take advantage to pay for it. I'm out of time, right?
Yes, now I wanted to give you the opportunity, if you have like a few more slides to wrap up, but
okay.
Just right now, we can't take any more questions just so he can complete his presentation. So we can...
Yes, let me be really quick. Let me go to what is the duration. Works under the 1909 Act, right? It depends on the date of publication. First term is 28 years, eligible for a second term of 28-year term if renewed on that 28th year. Okay? If it's under the 1976 Copyright Act, renewable term has increased to 47 years. The 1998 Copyright Act, Term Extension Act, the renewal term is increased to 67 years and can be protected for up to 95 years after the author dies. So they have extended the life of protections of copyright. So once it's in public domain, you're free to use it. But if it's not in public domain, you're not free to use it. So a good example is Steps to Christ. That is old enough that it's considered now public domain. Now, we do that, Venice. We ask you, if you're going to use it, contact the EG-wide estate according to the working policy, and let them know that you want to use it and how you want to use it. But legally, it's considered a work of public domain. All right? Jurisdictional reach. It's basically, there's no international right, copyright. All right, so when you file something in the US, it's protected in the US. If you file it in Japan, it's protected in Japan. If you file it in China, it's protected in China. However, there's a few treaties that are in place which almost provides a little bit of reciprocity between all of the parties that are in the jurisdiction, okay? But let me tell you this, if you have an infringement, you can only really start enforcing an infringement if it's registered. So that's one of the benefits. So you can copyright it by saying copyright, but if you want the protection of the law, you really need to actually register your copyright, okay? I'm going to fast forward to streaming music, all right? Does a church possibly, the scenario is, does a church have permission to stream its music?
What do you mean?
It all depends. Did you get the right license? Because let me tell you, there's a big exception. You can use copyrighted material like music and everything else in a church service. That is an exception. But the exception to performing music in a church does not extend to streaming that service online or selling, recording it and selling the DVD and all that other stuff. So once you start recording and selling it, you are outside of the exception of using protected work for religious services. So what do you need to do? Depending on what you're doing, are you recording to sell? Are you live streaming? You may have to get a master's use license. You may have to get performance use. You may have to get mechanical licenses. You may have to get a synchronization license. So how do you do that? The good news is there are services out there. CCS and CCLI is one of the top licensing places. You pay the fee up front for the year, and it gives you broad rights to a broad category of works for the intended use. So you have to be clear. We do live stream our services. We do record our services and then sell them. And then based on what you're saying you're going to use it for, they will tell you whether you can obtain a license for it. And then like we said, if you get one just for streaming, but then you think, okay, I have a streaming license, but then you decide to record and sell, that streaming license may not extend to you recording and selling the product. So make sure when you get the right licenses, you let people know what is the intended use, okay? Last example, and then I'm done. I'm sorry I went over. Church wants to make an arrangement of the classic hymn, Amazing Grace. And then they plan to record it, and this new arrangement, and have it as the background music on their website. Do they need a license to use it? Yes or no? No, why not?
Amazing Grace is public domain.
Exactly. Amazing Grace is an old enough song that it is a public domain, you can use it. What about if you want to say, we have this hose instead? Can you use it? Why not? It's copyrighted and it's still under the protection of the copyright, which means you need to get permission to use it for its intended purposes. So that's really what it is. It matters whether, and just because it's found in the hymnal does not make it public domain. So you have to make sure whatever specific work you're trying to work with or use, find out whether or not it's still under copyright protection or whether it's in public domain. And if it's copyrighted, you gotta get permission because it's cheaper to address it in the forefront than to try to get it on the back end, okay? So the biggest thing we want to tell you and leave you is best practices. Get permission from your copyright holders. Search to see if the work that you want to use is in the public domain. Don't assume because the material is on the internet, it's okay for you to use it. most likely it's not. Contact your legal counsel if you have any questions. And even when people are volunteering to do good work for you that you want to use and rely on, take some time to talk about what are the intentions, who owns it, and put it in writing so it's clear what were the intentions of the parties. So I don't have any time for additional questions, but this email is for Jennifer, who is our intellectual property group. So I'm her stand-in. This is the actual person that has the good information and can help you. We at the Office of General Counsel are happy to help you because it is cheaper for us to steer you in the way of doing things the right way than for us to receive that infringement notice that we have to negotiate, pay off, and then build your entities that are not flooded with money, like the post office may have been. So God bless you. Continue to do good work, but let's do the work the right way and not make mistakes.
Thank you, Josue. We appreciate that information. I know we all still have a lot of questions, but just as he mentioned, you saw the email address for Jennifer. Make sure you utilize it. I guarantee you she will respond. Now, Josue, are you saying that we can't contact you?
Yeah.
Just making sure.
If I can answer, I'll answer. If I can't, I'm gonna say, I know who knows the answer. But do good work, and God bless you all.
Thank you so much. We appreciate it. Was that helpful information for you?
Yes.
Okay, so how many of you already have some of the licensing that we saw there, the CCL? Okay, great. How many of you are seeking to get those as soon as possible? Okay, wonderful. Thank you again. We appreciate the presentation. And as I told you, you're not a stand-in, you are the presenter. And we appreciate what you shared with us today.
Real quick, if we have all of the licenses, yet still some of the songs are not covered. And the reason I'm asking is because sometimes as we're streaming, we get dinged on YouTube. We get copyright infringements because the bots are trolling and they catch everything. How do we handle that if we wanted to, per se, sell the sermon besides editing out the music?
If you want to sell the sermon and not the music.
Yes, or both.
The question is, the biggest thing is, do you have the right license? If you purchase the right license and that work is covered under the license for its intended purposes, great. Because you showing the license and said, no, I bought the license for its intended purpose and I'm using it within that scope, you're good to go. But if you make that mistake, like I said, the government has granted that person a monopoly to protect their work. So if it's outside the scope, then they have a claim against you.
Just so quick, I'm going to talk a little bit about that when I do the streaming.
Oh, okay.
Specifically, YouTube has a process to address the very question you asked.
Okay, great, thank you.
All right, thank you. So, because we kind of lost our break time, your break will consist of you standing up, stretching,
And
giving
sit down.
Phil time to hook up his computer, and then we'll go right to the next session. So you may commence upon your stretching.